Now, from things I've read and other people I've talked to who had the same experience, it just strikes me that the atmosphere at the law school must have been full of civil rights. That even though lawyers do all kinds of things, criminal law and corporate law and real estate law and all, that just seems to me like civil rights is just permeating the atmosphere. Is that your
Especially
memory?
during those years. That was between 56 and 59. And so Howard University was the place chosen for the dry runs for the Supreme Court cases. We had the opportunity to sit in on dry run arguments by Thurgood and Dean Nabrit and others. It was a wonderful experience. In fact, the Shuttlesworth case.
Tell me a typical experience.
The Shuttlesworth case was a good example. In 1959, the Supreme Court had a chance on a summary judgment motion to declare segregation illegal, to end the resistance. It was like a preemptive strike. And they denied it. They wouldn't, they denied relief in that case, which meant that that was another opportunity for them to end this separate but equal all deliberate speed foolishness. I mean, all deliberate speed is a really misnomer because constitutional rights are personal and immediate. That's, everybody knows that. So when you say all deliberate speed, which means we're going to postpone your personal and immediate constitutional rights. So when Shuttlesworth came along, the Supreme Court had a chance to abandon that, and it didn't.
What was the Shuttlesworth case about?
It was a summary judgment case on segregation and going out of a case in Alabama.
Fred Shuttlesworth.
Fred Shuttlesworth was the plaintiff.
And so they had a moot court, in effect, about this?
On the Supreme Court argument. They had a dry run of the Supreme Court argument.
And so what would happen? Tell me.
The lawyers would argue both sides, and someone would be the justice and would ask questions, and we had a chance to hear both sides, and then we heard a critique afterwards. And so I knew that the Supreme Court was getting an opportunity to dismantle segregation again, which they turned down.
Now, as a student, do you get to participate? Did you get to ask questions, or are you just an onlooker?
We were onlookers. These were lawyers of 25 or 30 of the top civil rights lawyers in the country. And we were just onlookers, and we didn't have a chance to.
But it's got to be a great learning experience.
It was tremendous, tremendous. And you know, what made it so helpful, later on, I took cases to the Supreme Court and gave them an opportunity to dismantle segregation, and they did the same thing. In 1965, I took Bradley versus City of Richmond Supreme Court. And the Supreme Court outlawed faculty segregation, but didn't say anything about the so-called freedom of choice. So that was a second chance they had to dismantle segregation, which told me something about the Supreme Court. And then in 1968, Mr. Tucker and I took Green versus New Kent up there. And then finally, they said now means now, dismantle it now. But I mean, root, branch, and barrel. But it was 68 as opposed to 54. They had 14 years the Supreme Court gave the South to get ready for Brown. And that was one reason why I decided to go into politics, because the legal process was so slow. And I felt frustrated that, you know, we finally had a decision and the Supreme Court keeps giving them more and more and more time. So I said, this stuff will never end this way.
But one thing that happens in the big movement for civil rights between the Brown case and your becoming a lawyer, well, is that more opportunities for more people to participate in this movement in more kinds of ways come up. The sit-ins come along.
Yes.
And all of a sudden, you don't have to be a lawyer to argue a case. You can put your body there and get arrested and go to jail. The freedom rides.
Right.
The Boynton case produces the freedom rides. And it becomes possible, if you don't have to be a lawyer, you can get on the bus. And so the areas of participation are much wider. But this also means that lawyers have much more business, civil rights business to handle. Now, what did this change in the business? It used to be that you'd file a lawsuit against some aggrieved wrong, perceived wrong, but now people are creating wrongs and bringing them to you and saying, help me, I've been arrested for something. How does that change in your, or does it change?
Well, civil rights lawyers rarely made a good living. Most of them were people who were committed. When Sam Tucker and I inherited Oliver's law practice in 1961, we handled school cases for a couple of years before we even thought about submitting a bill to anyone. The Legal Defense Fund was subsidizing the cases to a certain extent, and when we finally submitted the bill, it was 2 years after we'd been handling cases. And they reimbursed us on the basis of $50 per day for a case, and you know, lawyers were making $100 an hour. and we didn't care. I mean, most civil rights lawyers weren't involved for the money. In fact, they could have engaged in personal injury practice and other things that made more money. What the civil rights movement was, there was such a volume of litigation, and because of the NAACP and the Legal Defense Fund, there was some resources available to take care of expenses.
Well, how would you keep your office open?
We got other business from time to time, and the stipend from what we call the stipend from the fund, and finally we generated a notion called attorney's fees. That was generated in our office. The school board was so obstinate and so hostile. What happened was, it reminds me of Florida now, they took the application forms and moved them so that the parents had to run around the county. They couldn't get the forms to apply to the white schools. And we finally got the case to court. We said, look, why should the plaintiffs have to pay lawyers to go to court to get what these defendants are hiding from them? So the court came up with, said because of endured obstinacy, the defendant has to pay the fees. And that was the first case that allowed attorney's fees in civil rights cases, and eventually was adopted by HEW, and attorney's fees became a part of the law. But that started in our office.